the appointing process. That seems to me to be in direct contradiction to what is here.
My Lords, I don't think I've said this before in your Lordship's house, but I stand in almost constant awe of the noble Lord Wallace of Saltaire, because many years ago, when I left university and joined the Foreign and Commonwealth Office, his book, The Process of British Foreign Policy Making, if I have the title correct, was, if not quite mandatory for those of us joining, but was certainly highly recommended, and I read it with great attention. And I hope that I learnt much of it, both theoretically and to practical effect. And the thought, I've been here over 2 years in your Lordship's house, and I've never actually had the chance to say that I've always found that I'm slightly in awe of the fact that the very William Wallace who wrote that book is here and makes such a huge contribution to your Lordship's house, and indeed to my life. But in that respect, because I haven't risen to speak predominantly to the motion, to the amendment standing in his name, but rather to the earlier amendment, in that respect, I'll just say that the rosy picture the noble Lord paints of academics happily getting on together, disagreeing on theoretical matters of physics and generally not hindering each other's promotion or advancement or job prospects in any way, was, I'm sure, is in many ways an ideal and one that we should fight for. But I think is difficult to recognise in an age when we have seen professors effectively forced out of their jobs because they have views which are not sufficiently pro-trans or whatever, when it is hard to imagine, even in a science department, how somebody could question or advance research which challenge some of the bases of climate science. And in saying that, I'm not suggesting that I have any reason for bringing forward such science or that there is such scientific evidence, but theoretically were it to come forward, and how that would affect somebody's job prospects, how it would affect their chance of securing academic grants, and so forth. And I think it is those realities, and I do regard them as realities, that the amendment in the name of the noble Baroness Lady Fox of Buckley seeks to address. Now, the wording in the noble Baroness's amendment is, as I'm sure noble lords recognise, taken directly from various findings of case law of the European Court on the European Court on Human Rights, the Strasbourg Court. It is undoubtedly the case that case law in the Strasbourg Court defends strongly the principle that in a university, those who are employed by the university, especially those in an academic role, have an absolute right to criticise the university authorities, its conduct and its policies. And so the only objection, in my view, that can be raised to the amendment tabled by the noble Baroness is that it is otiose. We don't need it, because the right is already there and can be appealed to. So why do we need to put it in the bill? And the argument for putting it in the bill is really, in many ways, to make a demonstration to university authorities that these rights must be taken seriously. Now, I have to say, the cases in which these rights have been enunciated and vindicated by the European Court have difficult, in some cases almost barbarous names. They tend to come from parts of Europe and Turkey. They're cases like Erdogan, Sorguç, Aksu, Kula, Kalamov, which the noble lady referred to, and Ayuso Torres. They are not names that trip easily. They're not cases that trip easily off the tongues of the lawyers engaged by the majority of British universities to advise them in how to conduct these issues of free speech. Whereas the Equality Act, the Prevent Duty, the Public Order Act are pieces of legislation with which those lawyers are very familiar indeed, and are much more accessible to them. So there is a natural bias in defending free speech. This is the tension, if you like, that was at the heart of the debate in the earlier group. There is a natural bias amongst those giving legal advice to universities and those receiving that advice to pay attention to the legislation which has a tendency to restrict freedom of speech rather than the European Convention case law which defends it and vindicates it. So the argument, as I say, for the Noble Baroness's amendment is that it is not OTOs to include it, that these rights exist already, but they need to be referred to, that universities need to be reminded of their importance, and therefore the amendment should stand. Now, it's hard to know what I'd want to hear from the front bench in response to that, but I'd very much hope that they would be able to say that these rights expressed by the Noble Baroness are absolutely crucial and will be defended, and it's their intention to ensure that the Office for Students does defend them. However difficult they may be of access, they nonetheless form a proper basis for the conduct of universities, by contrast and in tension with the legislation which restricts free speech.
My